Okay, let's start. The Right Honourable name is Gloster, Mr. Neil Kaplan, Professor Lin Feng, Professor Christopher To, Ms. Joanne Lau, Ms. Helen Tan, member of the HIIC and member of CTU Law School. Ladies and gentlemen, welcome to the 29th of the Goff Arbitration Lecture. My name is Kwan. I'm your MC for tonight. And I'm currently a student for arbitration program at CTU Law School as well. And this evening, we are honored to have Right Honourable Dame Elizabeth Gloster to deliver the lecture on the topic, a practical guide to dealing with fraud in arbitration. Without further ado, I now invite the Dean of CTU Law School, Professor Lin Feng, to come on the stage to deliver the welcoming remark.
Distinguished guests, colleagues, ladies and gentlemen, on behalf of the Law School of City University of Hong Kong, I'm delighted to welcome you all to the 29th Goff Arbitration Lecture, whether you are joining us in person or online. First, I extend my heartfelt gratitude to Herbert Smith Freehills and the Hong Kong International Arbitration Center for their generous sponsorship of today's event. The Goff Lecture Series was established in 1990 by our law school to commemorate the launch of the Master of Arts in Arbitration and Dispute Resolution, which is now known as the Master of Laws in Arbitration and Dispute Resolution. The inaugural lecture was delivered by Lord Goff of Chivalry, a distinguished Lord of Appeal who graciously consented to lend his name to this series. The Goff Lecture has since become a prestigious platform for dialogue and exchange of ideas among practitioners and academics in the field of arbitration. Today, we are deeply honored to have the Right Honourable Dame Elizabeth Gloster with us. Liz served as the Lady Justice of the Court of Appeal from 2013 and as Vice President of the Civil Division from 2016 until her retirement in May 2018. She then returned to practice as an international commercial arbitrator at 1 Essex Court, Temple. Notably, she was the first woman appointed as a commercial court judge in 2004 and served as judge in charge of the commercial court from 2010 to 2012. Her illustrious career includes presiding over significant commercial and financial markets cases, such as JP Morgan Chase Bank against Springwell Navigation Corporation and the landmark Berezovsky against Abramovich trial. Since her return to Chambers in 2018, Liz has been appointed as both chair and a co-arbitrator in numerous international arbitrations, spanning a wide array of sectors, including insurance, reinsurance, banking, financial services, gas and oil, shipping, construction, joint venture, BIT disputes, etc. Her vast experience in adjudicating complex factual and legal disputes is further exemplified by her role as one of the 25 members of the arbitration panel under the EU-UK withdrawal agreement. In November 2020, she delivered a pivotal report following her investigation into the FCA's regulation of London capital and finance. And in September 2023, she was appointed Deputy Chair of the Takeover Appeal Board. Now, I'd also like to take this opportunity to say a few words about our Master of Laws in arbitration and dispute resolution program, which I mentioned a bit just a minute ago. As the first master's degree program in arbitration and dispute resolution in Asia, it has for almost 35 years equipped lawyers and related professionals from Hong Kong, mainland China, and beyond with comprehensive training in all aspects of dispute resolution, particularly in arbitration. Our program is internationally recognized for its excellence, with many graduates becoming leading experts in arbitration, mediation, and other forms of alternative dispute resolution. So now please join me in welcoming Liz to share her insights on the topic, red flags or white flags, a practical guide to dealing with fraud in arbitration.
Well, thank you very much, Professor, for that kind introduction. One can never really believe that one's being spoken about in such kind terms, so I appreciate it. It's a privilege to have been invited to give this lecture this evening, considering in particular the very distinguished predecessors in my role, and I'm truly honored, so thank you. Since 1996, numerous international instruments have been adopted to combat corruption or to attempt to do so, including the United Nations Convention Against Corruption 2003. It was within this context of greater attention being paid to corruption by the international community that the tribunal in Himperna against PLN as long ago as 1999 made the following statement. The arbitrators believe that cronyism and other forms of abuse of public trust do indeed exist in many countries, causing great harm to untold millions of ordinary people in a myriad of insidious ways. They would rigorously oppose any attempt to use the arbitral process to give effect to contracts contaminated by corruption. So nothing new then or today. So 26 years later, this statement and its practical implications for international arbitration remain as relevant as they were then. The 2024 Annual Corruption Perceptions Index reports that between 2012 and 2024, perceived levels of public sector corruption decreased for 32 countries, but increased for 47, with 2 out of 3 countries surveyed scoring below 50 out of a possible 100. This has important considerations for international arbitration, which, as we all know, is the preferred mechanism for cross-border disputes in many of those industries most exposed to the risk of corruption, such as, for example, the energy industry. It is therefore important, I think, that tribunals, as the custodians of the system of international arbitration, are able to steer a course between meeting the reasonable expectations of arbitrations users on the one hand, and addressing corruption or fraud where necessary. Indeed, the ICC is currently conducting an international review of how fraud is dealt with in arbitration, with the report due later this year. It's against this background that the English High Court delivered its recent decision in Federal Republic of Nigeria against Process and Industrial Developments Limited, which I'll refer to as Nigeria against PNID. It set aside an $11 billion arbitral award rendered in relation to a contract that had been procured or apparently procured through bribery. Mr. Justice Knowles was clear about his dissatisfaction with the tribunal's handling of the arbitration, further expressing doubt as to the ability of international arbitration adequately to address corruption. The decision, and in particular, Mr. Justice Knowles' comments, has focused a spotlight on the question of corruption in international arbitration discourse, enlivening discussions about whether arbitrators have a power or even a duty to address corruption where not strictly necessary to decide the issues raised by the parties. In this lecture, I'll outline Knowles's comments in the Nigeria case, drawing out his primary critiques of the tribunal. I'll then set out the approach of the English courts to issues of illegality, such as corruption, before going on to consider the potential differences and similarities between litigation and arbitration in this respect. I'll conclude with what I hope will be some practical advice on how arbitrators might approach issues of corruption, fraud, or illegality generally. Nigerian P&ID concerned a gas supply and processing agreement between P&ID, under which P&ID was to receive wet gas, process it, recompress the residual pipeline quality lean gas, and make the lion's share available to the government of Nigeria for power generation. The agreement was brief, given the magnitude of the 20-year project it sought to regulate, with Knowles J. remarking on its skeletal terms in the context of a multi-billion-dollar long-term project of national significance. In addition to its brevity, the terms of the GSPA were strikingly uneven. Nigeria had inter alia an absolute obligation to provide the wet gas to P&ID by the last quarter of 2011, where P&ID's obligation to implement the project promptly was merely one of best endeavors. This may in some part be explained by the fact that during the negotiation of the GSPA, P&ID had been making payments to a Mrs. Grace Tager, a lawyer, surprise, surprise, advising the Nigerian Minister for Petroleum Resources. After the GSPA had been concluded, P&ID made false statements to Nigeria about its ability to construct the gas processing facilities, stating, for example, that funding had been secured and necessary engineering work had been carried out. Unbeknownst to Nigeria, P&ID was in no position to carry out its obligations under the agreement. However, when Nigeria failed to secure the necessary wet gas after its supplier withdrew from negotiation, P&ID purported to accept repudiatory breach and initiated arbitration seeking damages. P&ID continued to make payments to Ms. Tager during the arbitration, presumably to buy her silence, and repeated certain false statements as to its ability to fulfill its obligations under the agreement in its witness evidence before the tribunal. P&ID's witness evidence had also been drafted to mislead the tribunal in that, despite purporting to explain how the GSPA came about, it, not surprisingly, omitted any reference to the payments to Ms. Tager. In addition to bribery and false evidence, during the arbitration, P&ID came into possession of a substantial quantity of Nigeria's privileged legal advice without Nigeria's knowledge. P&ID's lawyers were aware of the privileged nature of these documents, but did not tell Nigeria that P&ID had got them. It later transpired, and this is the amusing aspect of the case so far as lawyers are concerned, that P&ID's barrister and solicitor were promised contingency fees of up to £850 million and £3 billion respectively. Sadly, not an offer or brief fee that's ever been offered to me. Nigeria grossly mismanaged the arbitration. It missed deadlines, failed to provide instructions to its legal team, and struggled to fund its defense due to internal politics as to which government entity should be responsible for the costs. As noted by Mr. Joles, there was not a fair fight. Nigeria lost on liability, and at the quantum stage, P&ID was awarded $11 billion, the full amount claimed. Nigeria subsequently discovered the bribery of Ms. Tega through criminal investigations into P&ID and initiated set-aside proceedings in England under Section 68 of the Arbitration Act 1996 on the basis that the award had been obtained by fraud or had otherwise been obtained in a manner contrary to public policy. Within the Section 68 proceedings, Nigeria then found out about the retention of its privileged documents by P&ID when P&ID's new solicitors informed Nigeria that they'd identified documents over which Nigeria likely had privilege. Nigeria succeeded at setting aside the award on the basis that P&ID had relied on false witness evidence, had retained Nigeria's privileged documents, and had continued to make payments to Ms. Tega during the arbitration. Mr. Justice Knowles was highly critical of the arbitration, calling it a shell that got nowhere near the truth, and levying criticism not only against Nigeria, but also the tribunal in particular. He posed the following pointed rhetorical questions. The tribunal took a very traditional approach. Not quite sure what that means, I interpose. But was the tribunal stuck with what the parties did or did not appear to bring forward? Could and should the tribunal have been more direct and interventionist when it was so clear throughout the arbitration that Nigeria's lawyers were not getting instructions, or when at the quantum hearing, Nigeria's then leading counsel, Chief Ayarindi, was failing to put necessary points to experts to test their opinion, and Nigeria's own experts, for whatever reason, had not done the work required? Should the tribunal have taken the initiative to encourage exploration of new bounds of contract law and the law of damages that may today be required where major long-term contracts are involved? Mr. Justice Knowles's answer to at least some of this question seems to have been yes, as he had formed the view that, and I quote, "I do not consider the tribunal did all that it could do to find out more about the points by questions of Nigeria's legal representatives." Query whether those were right comments to make. First, arguably, Knowles J. went beyond the scope of the Section 68 application. In particular, his comments on both the inadequacies of Nigeria's legal defense and the proper approach to be adopted by a tribunal in response to such adequacy arguably goes beyond the supervisory role that the English court is expected to play, where the parties have chosen to submit their disputes to arbitration and not litigation. Secondly, Mr. Justice Knowles opined on confidentiality as a potential obstacle to justice in major disputes involving states, asserting that, quotes, "the privacy of arbitration meant that there was no public or press scrutiny of what was going on and what was not being done, whereas, quotes, an open process allows the chance for the public and press to call out what is not right," end quotes. Now, that may be a good advertisement for the commercial court, but is it a fair critique of the arbitration process? Whilst, in my view, there's room for sensible disagreement as to the merits of greater transparency in disputes involving states, and notable efforts are being made in this area, such as the UNCITRAL rules on transparency in treaty-based investor-state arbitration, it is not, in my view, the role of the court in a Section 68 challenge to an award to wade into this complex policy debate. Mr. Justice Knowles's comments might be regarded as an attack on the system of international arbitration itself and perhaps risks undermining England's reputation as an arbitration-friendly jurisdiction. Whatever one thinks of the appropriateness of Mr. Justice Knowles's comments, and I do invite you to look at those passages of the judgment where he directly criticizes the tribunal's apparent decision itself on the merits of the case, which goes way beyond, in my view, his review for Section 68 purposes of whether there was corruption in the procuring or of the award or the conduct of the arbitration. But whatever one thinks of the validity of his comments, it cannot be denied but that the Nigeria case has shone a spotlight on the question of how, when, and whether international arbitrators should address corruption where it is not strictly necessary to do so in order to dispose of a dispute as pleaded by the parties. In this respect, I think it might be helpful first to consider how this thorny issue is approached by the English courts by comparison. So let me just look for a moment at fraud before the English courts. It's a general principle of English law that a party should be prevented from using the court to obtain benefit from his or her wrongful conduct. Whilst this is often referred to as the illegality defence, it is important to note that the court is not a passive actor when faced with a party seeking to benefit from its own wrong. For this reason, it might be more correct to refer to it as the illegality principle, as stated by Lord Sumption in the Supreme Court decision of Patel and Mirza. I quote, "Whatever rationale one adopts for the illegality principle, it is manifestly designed to vindicate the public interest as against the interests and legal rights of the parties. That is why the judge is required to take the point of his own motion, even if the parties have not raised it." Whilst this might seem at odds with the adversarial system of English justice, involving as it does the judge's descent into the arena, it's important to emphasize that any benefit derived by a defendant is coincidental to the operation of the illegality principle. As I myself noted in the Court of Appeal in Patel, citing Lord Mansfield in Coleman and Johnson, it is not for the defendant's sake that the objection is ever allowed, but it is founded in general principles of policy, which the defendant has advantage of, contrary to the real justice as between him and the plaintiff by accident. However, as I further noted, this time citing Lord Justice Bingham, as he then was in Saunders and Edwards, it is not enough to show some form of illegality in the conclusion of the contract, regardless of the severity of that illegality or the strength of its relationship with the underlying transaction. That is what one has got to look at, I think, in all cases, both in the court context and in the arbitration context. Nor, said Lord Justice Bingham, should the court be overly anxious at the first potential signs of illegality. He said, it's unacceptable that the court should, on the first indication of unlawfulness affecting any aspect of the transaction, draw up its skirts and refuse all assistance to the plaintiff, no matter how serious his loss, nor how disproportionate his loss to the unlawfulness of the conduct. And I think that is the golden thread. And I myself reflected that. So the English court will not jump at its own shadow looking for illegality. The English courts will require such illegality to be proved on the balance of probabilities. However, the balance of probabilities test is not static and takes into account the nature of the allegation being made. Nor on finding illegality will the court automatically refuse a claim. Context will be a critical factor when considering the effect of illegality on the enforceability of a claimant's rights. It's important that a party must not be denied rights purely as a punishment, regardless of proportionality, and there should be a sufficiently close relationship between the illegality and the right which the claimant seeks to enforce. The current test under English law requires the court to consider the following three factors in determining whether or not a claim should be rejected for illegality. First, the underlying purpose of the prohibition, which has been transgressed, and whether that purpose will be enhanced by denial of the claim. Two, any other relevant public policy on which the denial of the claim may have an impact. And three, whether the denial of the claim would be a proportionate response to the illegality, bearing in mind that punishment is a matter for the criminal courts. And here may I boast a bit to say that that articulation of the current test for illegality in the Supreme Court in Patel and Miser endorsed my dissenting approach in the Court of Appeal, where I articulated precisely that approach. Again, I'm quite keen on this idea of not shying away from illegality and denying parties all their rights. In another dissenting judgment of mine in the Court of Appeal, in UBS Global Asset Management UK Limited against Kommunale Wasserwerk Leipzig, which I'll refer to as the UBS v KWP, I said, when refusing to introduce concepts of trust into a commercial transaction where an intermediary broker had been what I regarded as slightly dishonest, I said, it's impractical and unreal to introduce into commercial transactions the moral standards of the vicarage. I'm afraid to say that my colleagues did not agree with me in that case and went on to impose fiduciary obligations. But let me explain my colourful statement a bit further. In my experience as a judge, and particularly as a dissenter as I was in UBS v KWP, the real commercial world, if not appropriately described as a dirty world, is and should realistically be recognized by the law as a tough marketplace. Displays of the milk of human kindness do not normally generate huge profits in any of the areas with which we have to deal as commercial judges or arbitrators. Whether in arbitration or litigation, I think it is very rarely appropriate to impose trust or fiduciary obligations on parties who are engaged in commercial transactions where each side is out to gain whatever profit they legitimately can, and where the contract between them does not impose such fiduciary or trust obligations. Let's turn now to fraud in arbitration. The first point to note is that arbitrators act pursuant to a contractual mandate given to them by the parties to decide a particular dispute. Unlike judges, they're not officers of the state, and therefore they lack a mandate to, quotes, vindicate the public interest as against the interests and legal rights of the parties, as Lord Sumption put it in Patel. After the Nigeria case, Lord Hacking in the House of Lords sought to amend the then arbitration bill, now the UK Arbitration Act 2025, to include, he sought to amend it to include an express obligation for arbitrators to safeguard arbitration from fraud. This amendment, in my view, was rightly and soundly rejected, as such an obligation would be unworkable in practice and might provide an unwarranted further basis for challenging arbitral awards. During the discussion of this amendment in the House of Lords, Lord Beath commented that the Nigeria case showed that the current law suffices to combat fraud. However, that is debatable in circumstances where Nigeria's Section 8 challenge succeeded, not because not because PNID had obtained the agreement through bribery, but because it had relied on false evidence and obtained Nigeria's privileged documents in the conduct of the arbitration. As noted by Mr. Justice Knowles himself, I end the case acutely conscious how readily the outcome could have been different. I highlight the possible consequences if P&ID's lawyer had drafted P&ID's witness evidence a little more cautiously, and if P&ID had not retained Nigeria's internal legal documents during the arbitration. So the message, I think, is Section 68 or its equivalent is no cure for corruption necessarily in the underlying transaction. That issue falls under the jurisdiction of the tribunal in the first instance and not the court. In the absence of any proposed statutory obligation to address fraud in arbitration, the question arises as to whether a tribunal has the power to do so or should do so, where the parties have not raised it as an issue to the dispute. Two approaches to this question deserve mention. The first approach is one advocated by Gary Bourne and relies on the tribunal's duty to apply relevant national mandatory rules of law. According to Gary Bourne in his book, International Commercial Arbitration, which I'm sure is bedside reading to all you students, he said, it's a vital precondition to the fulfillment of their mandate that the arbitrators consider and decide claims that contractual agreements are invalid, unlawful, or otherwise contrary to applicable mandatory law and public policy. Without such consideration and decision, the tribunal cannot make an award that decides the party's substantive legal rights in a binding way, inherent in the legally binding resolution of dispute and the making of a legal binding award is the duty to consider and resolve public policy and other mandatory legal objections. Well, that doesn't actually give you much guide as arbitrators as to whether you should dig deep and go in. The late Emmanuel Gaillard seems to have taken a similar approach, though he relied on applicable transnational rules as the basis on which a tribunal should consider the question of corruption in international arbitration. He stated that there is little doubt that a transnational rule has been established, according to which a contract or an investment that has been reached by means of corruption should not be given effect. Again, that's a little bit airy-fairy to me, doesn't really give me a guide. A second approach is based on the tribunal's duty to make reasonable efforts to render an award that is enforceable at the seat. Some institutional rules expressly provide for such a duty, an example being the LCIA Rules 2020, Article 32(3) of which states that the arbitral tribunal shall make every reasonable effort to ensure that any award is legally recognized and enforceable at the arbitral seat. Where the enforcement of legal rights procured through fraud or corruption poses a known risk to the enforceability of an award, the tribunal might legitimately raise the issue of corruption itself. However, it must be recognized that although tribunals do indeed have a general duty to ensure that they render an enforceable award, they do not in practice, and could not in practice, go on to consider specifically whether their award would be consistent with the public policy of each possible enforcement jurisdiction, especially where there are many possible enforcement venues. In general, in my opinion, it suffices that the tribunal is satisfied that the award does not violate obvious international norms of public policy. To that extent, I go along with the late Emmanuel Gaillard. An example of an award set aside for corruption in the underlying contract can be found in the case of Webcor against Gabon. The French Cour de Cassation set aside an award where it transpired that Webcor had financed a luxurious honeymoon trip for a local official in Gabon. Similarly, under English law, an award may be refused enforcement for illegality. In Soleimani against Soleimani, the English court refused to enforce an arbitral award between parties who had agreed to smuggle Persian carpets from Iran in breach of Iranian law. Walad LJ, giving the judgment, noted that the court declines to enforce an illegal contract, not for the sake of a defendant, nor, if it comes to the point, for the sake of the plaintiff. The court is, in our view, concerned to preserve the integrity of its process and to see that it's not abused. The parties cannot override that concern by private agreement. They cannot, by procuring an arbitration, conceal that they, or rather one of them, is seeking to enforce a legal contract. Public policy will not allow it. However, that approach has subsequently been criticized in the subsequent Court of Appeal case by Westacre, and indeed in the Singapore case of AGU against AGT, both of which criticized the approach taken by Lord Justice Waller. But the need for a tribunal to raise issues of corruption and fraud, as one can see from the Soleimani case as an example, is not restricted to situations where one party has defrauded the other. It is particular of importance where both parties are complicit in an illegal enterprise, such as where they're both involved in smuggling or money laundering. In such situations, the tribunal must be alive to the risk that it is being used as an instrument to further the party's illegal enterprise. And what about, for example, the current issues of sanctions? Even if a license has been given, what is the tribunal meant to do? If the parties don't raise it, and it's obvious that it might be a sanction situation, or the contract or performance of obligations of the contract might have been in breach of a sanctions regime, is it for the tribunal to raise it when the parties don't? Question, question, question. In my view, Patel and Mirza is actually a guide and remains a guide even in the context of arbitration. In my view, whether the tribunal should raise the question or deal with the question of illegality or fraud hinges on the relevance of the fraud to the resolution of the parties' dispute and the legitimacy of the tribunal's decision where fraud goes unaddressed. And a tribunal should, in appropriate circumstances, consider itself entitled to raise the issue of corruption or illegality where it's relevant to the claims being made. However, whether the tribunal has the power to raise corruption of its own motion, sua sponte, is a separate question from the circumstances in which fraud is sufficiently apparent to make exercising that power appropriate. Due to the confidential nature of arbitration, it's difficult to say how frequently tribunals do exercise the power to raise of their own motion issues of what they think may be fraud. There's two notable cases, and I'm sure there are more, in which a tribunal has exercised this power in some form. One was the ICC case 1010 of 1963, which concerned a contract under which the claimant was to receive a commission for using his influence to obtain business for the respondent in Argentina. In cross-examination, the respondent's undisputed witness evidence asserted that the commissions were to be used for bribes to obtain contracts for the respondent. So it was the respondent's own witness. The tribunal held that corruption was a relevant issue going to jurisdiction, holding that a case such as this, involving such gross violations of good morals and international public policy, reflection on Gaillard again, can have no countenance in any other court, in any court, either in the Argentine or in France, or for that matter, in any other civilized countries, nor in any arbitral tribunal. Thus, jurisdiction must be declined in this case. In the subsequent case, in Metaltech and against Uzbekistan, Uzbekistan had alleged corruption by Metaltech in its pleadings. However, it was not until Metaltech's CEO admitted paying millions of dollars to consultants for lobbying that the tribunal exercised its powers ex officio to require additional evidence addressing the question of corruption. Both of the above cases involve the admission either of corruption itself or of facts strongly indicating corruption. Whilst the case does not, in my view, need to meet this high threshold for the tribunal to make inquiries into the issue of corruption of its own motion, in my view, a tribunal should be slow to intervene in this matter without having real circumstances suggesting fraud or corruption. Raising fraud by the tribunal of its own motion will necessarily lead to further delay and costs. Institutional rules, as well as Section 33 of the English Arbitration Act, require tribunals to adopt procedures that will involve necessary cost and delay in the conduct of the arbitration. A tribunal must therefore, in my view, balance the benefit and relevance of threshing out the issue of fraud against the desire for cost and time efficiency in arbitration. Thankfully, there is ample material to which a tribunal might have recourse in considering whether a particular case warrants such intervention by an arbitrator. These resources set out a number of red flags that a tribunal might take into account in assessing whether a transaction has been infected by corruption. As previously stated, these resources are expected to be supplemented by the ICC's report on addressing corruption in international arbitration by the end of this year. Of particular note is the Toolkit for Arbitrators issued by the Basel Institute for Governance, which sets out red flags for tribunals to take into account on suspicion of corruption or money laundering. Notable red flags for corruption in the toolkit include the prevalence of corruption in the country, as revealed by certain international organizations, such as the Transparency Index, to which I've already referred, the existence of criminal investigations carried out by domestic authorities during or before the arbitration, the involvement of intermediaries' paid commission that is not in proportion to the work done, or otherwise paid commissions on a percentage basis, where an intermediary claims expenses which are not related to the actual expenses incurred, and inaccurate or complete financial statements. In relation to money laundering, the toolkit notes the following red flags. The dispute is particularly one-sided. The respondent does not participate in the arbitration or otherwise basically acknowledges liability. The absence of documentation for the background of the dispute. The companies involved seem to lack any business activity. The involvement of persons or funds from countries with a known risk for crime and corruption. Those seem, again, a bit vague to me, because one can often be in that situation. Moreover, even where corruption or fraud seems apparent in the background to the dispute, an arbitral tribunal should, in my view, only raise the issue of its own motion where the relevant illegality is relevant to the dispute before it. This reflects the approach of the English courts, which will not invoke the illegality principle unless the illegality at hand is sufficiently serious and has a sufficiently close relationship with the rights being claimed. And I've already rehearsed the test, the approach in Patel and Mirza. We have to remember that the tribunal is not a policeman or detective. It's there to decide claims and adjudicate on defenses. But if it thinks that an illegality defense might negate a claim, in my view, it should raise the issue for discussion and possible determination. Importantly, and this is critical, particularly in circumstances where illegality or circumstances suggesting illegality might arise at a late stage in the evidence, the necessary procedural steps must be taken to allow the parties to address the issue of corruption in circumstances where it is raised by the tribunal or raised by one party at a late stage. This will require advance notice to the parties that the tribunal has concerns about the legality if it is raising it, and the invitation of both evidence and submissions on the point. However, there is always another story. I must mention the category of case in which a tribunal should, in my view, rule on fraud allegations raised by one party against the other, despite there being no strict need to do so in order to determine the contractual or tort claims as between the parties. In my view, a need to do so does or can arise where, despite the absence of any strict legal need to decide fraud allegations, there are nonetheless significant reputational issues which can adversely affect one party or the other in their future dealings in the particular industry or territory. Such situations are not uncommon, as parties to arbitrations will often insinuate, without actually alleging or proving, corruption or fraud by the opposing party, without going on to substantiate such insinuations. In his 1994 dissenting opinion in Thunderbird and Mexico, Professor Velder noted that, quote, "It has become more and more frequent in investment arbitration as both claimants and defendants raise such hints without being ready to submit them to a full and fair trial, calling such tactics a poisonous way to conduct litigation." Let me give an example of my approach in a recent commercial arbitration in which I was involved. The claimant claimed damages for alleged wrongful termination of an agreement for the supply of equipment. There was a cap on the amount of such damages, save in circumstances where the claimant could establish that the relevant breach was caused as a result of a fraud on the part of the respondent. The claimant pleaded a case in fraud against the respondent on the basis of forgery of certain documents so as to justify the quantum of its claim for damages in excess of the contractual cap. It was said that the documents were used to procure the consent of a particular state department to the release of funds for the purchase of the equipment. The respondent's case was that, although it admitted that one of its employees had been fraudulent, the claimant was complicit in the forgery of the relevant documents and in their subsequent fraudulent deployment. The respondent relied on the principle as articulated in Alga Hussein Establishment against Eton College and submitted that that principle operated to preclude the claimant from relying on the fraud exception in circumstances where the alleged ability to do so was premised on wrongful conduct for which the claimant bore responsibility. In the event, in this arbitration, the issue of fraud or forgery was moot because we, the tribunal, decided that as a matter of contract, there'd be no wrongful termination by the respondent, and that therefore, in any event, the claimant was not entitled to damages. Therefore, the issue of the cap on the quantum, did the fraud carve-out apply or not, strictly never arose for us to decide. However, we, the tribunal in that case, nonetheless considered it appropriate to ask for and address the evidence of the fraud issue and reach a determination. We actually required further evidence on it, although there was some evidence on it, because we took the view, rightly or wrongly, that where one party makes serious allegations of fraud against another party, and that party responds by making correspondingly serious allegations of complicity against the accusing party, and then a considerable amount of time is spent on those issues at the hearing, it would be inappropriate that a tribunal should decline to come to any conclusions in relation to the serious factual issues raised. There was also the risk that if the issue remained undecided, the claimant might have been in a position to deploy the allegations which it had made in the future. We also took the view that apart from the reputational issues, there would have been a real question as to which party should bear the costs relating to the issue of forgery in the event that the issue remained undecided. So we ruled on it. And that to me was interesting, an issue that had been raised by the parties, but only by the claimant, but only in a nebulous sort of way, without really the full evidence on the topic, because the respondent initially wasn't too keen to go there. But we asked for further evidence, we received further evidence, and we decided the issue, albeit that it was moot. But in my experience, tribunals will often sidestep the thorny issue of deciding an allegation of corruption. For example, in its decision on jurisdiction, the ICSID tribunal in Bayandir against Pakistan held that as Bayandir had alleged other facts capable of making out a claim for breach of the fair and equitable treatment, quotes, there is no need for the tribunal to discuss Bayandir's additional allegations of corruption at this stage. While in rendering its decision on the merits, the tribunal commented that it had taken into account that the record does not support Bayandir's allegation of corruption in the tendering process, but difficult to make that, as it were, superficial reasoning without actually going on to decide it. So corruption was not addressed as an independent issue there. And that case exemplifies the reluctance of arbitrators, in my experience, to grasp the nettle in deciding allegations of corruption. An allegation of corruption or fraud should not be made lightly, however. This is reflected in the ethical obligations imposed by the Bar Standards Board on English barristers. And I'm sure you've got similar obligations here, which prohibits, quote, any allegation of fraud unless there are clear instructions to allege fraud and there is reasonably credible material which establishes an arguable case of fraud. Where such allegations are made in an arbitration, it is important in my view that they should be withdrawn or decided, as they will implicate not only companies or states, but private individuals or companies who may well want the opportunity to refute such allegations. Professor Velder is right, in my view, to state that wanton allegations of fraud are a poisonous way to conduct litigation. I would question whether a tribunal, in sidestepping an allegation of corruption, truly complies with its duty to act fairly between the parties by leaving a serious allegation hanging over one of them. Tribunals must, in my view, in appropriate circumstances, be prepared to determine the issue, regardless of whether their decision on other issues means that the issue of fraud is not dispositive of the parties' dispute. But of course, it all depends. It depends on the circumstances of the case, the seriousness of the allegations being made, the proportionality of the allegations to one party's claim, all the type of considerations that the UK Supreme Court articulated in Patel, which is probably why this lecture may have been little use to any of you in providing the golden thread as to when we as tribunals should indeed grasp and decide nasty, poisonous allegations of fraud. But nonetheless, thank you for your patience.
Thank you, Elizabeth Gloster, for delivering the insightful lecture to us. Now, I would like to invite Mr. Neil Kaplan to lead the discussion session.
Can you hear me, first of all?
Yes, we can.
Liz, I can't see you. Thank you very much for that lecture. It was very interesting and it deals with a very important point that does come up, unfortunately, more often than it should. So I have a few questions for you. Can you hear me all right?
Yeah, I can hear you. Shall I move? I'll move in case you can see me.
Yeah, that would be better.
Is that better?
Yeah, that's fine.
Can you see me now?
I can see you now.
What time do you have, Neil?
Well, it's nearly tomorrow here. So it's quite late. I wanted to start off
You're
just by
very
asking.
noble. I think you're very noble, and thank you for having asked me to give this lecture.
Thank you. Thank you for accepting the invitation. Do you think that the criticism of the tribunal in the Nigeria case is really fair in all the circumstances?
I don't actually. I think, I mean, by way of example, he was extremely critical of the actual findings of the tribunal on the facts as they stood before the tribunal. Look at paragraph 314 of his, or 312, 314 of his judgment. He criticized the reasoning of the tribunal on the contractual approach. He shouldn't have been doing that, in my view. He then goes on to say, it's not for me as a judge of the court where the parties have chosen arbitration to resolve their dispute, to decide the merits of the dispute. That task and responsibility has been given by them to the tribunal. I'm also acutely aware of the distinction and experience of the tribunal. But I do have to look at what was argued and what was not argued. And then he goes on in 314, basically to criticize the analysis of the tribunal. And okay, he may have disagreed with them, but he wasn't dealing with it on the facts as they were before him, before the tribunal. And he made similar, in my view, unjustified criticisms. I hope Robin's not listening into this, that's all. About the quantum findings by the tribunal in Nigeria. And again, of course, as it now transpires, the arguments were not being properly put either by the expert who Nigeria fielded or by counsel. But that to me has clouded the approach in what was a very special case, in the sense of this wasn't just a question of the underlying contract being obtained, apparently by these actually very small payments to the government official, very small payments in the context of things. That really wasn't the basis of the case. So I don't think they were fair or appropriate.
Well,
What do you think?
Well, I'm asking the questions.
Oh, right, sorry.
No, I agree with you. I agree with you entirely. But let me ask you this. What do you think, without the benefit of hindsight, you would have done if you'd been there? Would you have done anything differently to what the tribunal did?
It's quite difficult without being there. And although obviously one's read the judgment more than once, to get a feel of how bad it was is quite difficult. I mean, really distinguished tribunal, I'm not sure I would have done anything different. I mean, I'd like to say, with the benefit of hindsight, I might have asked for instructions. I might have been worried, because I was often worried sitting as a judge about whether the decision taker was actually giving proper instructions. And I think I might have said, look, this case is being, or might have thought this case is being so badly run, I think I need to have somebody from the Nigerian government with authority to explain to me why they aren't taking this case seriously. I think I might have done that.
Yes.
It's very, I'd be interested what other people think as well on that.
Yeah. Well, I mean, the essence of the judgment and its attack on arbitration is really the judge saying, if this had been in this commercial court, I'd have got to the bottom of the truth. But the question is, with all the corruption that was going on and the incompetence of counsel that Nigeria itself chose, would it necessarily have come out in commercial court proceedings or any other proceedings in a court of law?
I don't think so. I don't
No.
think it would necessarily. I mean, I think if I was in the commercial court and I saw such woeful representation on the part of the state, as I just said, I
Yeah.
might say I'm concerned about the fact this case doesn't seem to be taken. I want to see somebody, you know, with real authority and to get a proper explanation of why things aren't happening. I think I might have done that at a procedural stage, but absent that, I don't see it would have come out until the Nigerian state had done its investigations of both P&ID and also investigated Ms. Tiger and realized that they were corrupt.
And then instructed competent solicitors, as they did.
Public counsel and
And then it all
solicitors.
came out, yes.
Yeah.
Now, you mentioned Patel and Mirza, and are you sure that the trio of considerations which the Supreme Court and you said should be applied is easy to apply as opposed to the rather strict view that was previously in place, Tinsley and Milligan, that if you had to rely upon an illegal contract, that was the end of it?
Well, you know what my view is. Yes, I think it's I think this more flexible,
Yes.
proportionate approach, for the reasons that I gave in my judgment in Patel and Mirza, is not difficult to apply. It's much more sensible, and the reliance point is a kind of awful procedural point. And I noticed, because you told me, I think, that in this jurisdiction, the Court of Appeal, I'm not sure whether the final Court of Appeals, but the Court of Appeal has adopted the latest articulation.
It has now, yeah. So let me ask you this, if Mr. Mirza had invested 50,000 of the 600,000 and made a loss on the shares that were bought with it, would you have allowed Mr. Patel to recover the 550,000?
Oh, goodness. This really is an exam question.
I'm just trying to get, I'm just trying to get at how far, you know, the trio of considerations interacts with the standard view of relying upon a legal contract. Would you have sort of divvied it up a bit?
No, I think I would have. Hang on, just give me the facts again. Remind me.
So
Neil,
Patel pays 600,000
Yeah.
to Mirza, so Mirza can make an investment with the
Yeah.
benefit of insider dealing.
Yeah, absolutely. And
he
so
doesn't,
Mirza got the money.
He doesn't do anything.
Yeah, fine. And your hypothesis is?
That he actually uses just 50,000 of it to buy some shares which make a loss.
Oh, no, I wouldn't let Patel recover in those circumstances.
You wouldn't, right?
Because the deal between them was that he would bear the losses if they bore a loss. So why should, if 50,000 of shares are bought in accordance with their contract, which on the analysis in the case was not affected by illegality. No, the deal was that Mirza would buy the shares. It was all hoped they were going to make money. So the answer, no, I wouldn't, but that's contractual, nothing to do with illegality.
Right, okay. Now, you mentioned the issue of whether or not tribunals should deal with fraud, and they shouldn't jump under the table when fraud is mentioned, and I agree with you on that. But what happens in a case like, for instance, assume that the claimant is claiming money under a contract or claiming something under a contract, and assume the defense is this wasn't a valid contract under English law, it was just an agreement to agree. We get some of those cases, as you know. Yeah. But in the course of the pleadings, the respondent said the contract was subject to fraud, was the subject of corruption. Now you decide that there is no contract, therefore there's no need to do anything. Would you still decide the issue of corruption, which is not necessary to your decision?
In that plain vanilla analysis,
Yeah.
I wouldn't, no,
Right.
because unless the respondent said there were reputational issues, there were consequential reputational issues for it or its corporation in the area, whether the industrial, the area of the business or the geographical area, in which case as a tribunal I might do so. I mean, there can be circumstances in which you said
You-
the claimant, sorry, it would be the claimant
Yeah.
in those circumstances, wouldn't it?
You're dismissing the claim because you're saying there's no contract. Therefore, the contract couldn't have been.
Yeah.
It wasn't necessary to decide whether the contract was procured by fraud or by corruption. But you've had the evidence. You've had the evidence. Would you still make a decision, even though it wasn't necessary for your actual decision?
I think it might depend on the nature and extent of the evidence. It might also depend, I mean, how much one had gone into it, how obvious it was. If the claimant was saying, say it's a very hotly disputed question of corruption, okay?
Mm.
And the claimant is saying, I would like you to decide this because my claim is it is a valid contract, and if I'm right in that, you'll need to decide it. And in any event, there are reputational issues for me or my company if you don't decide it. But if, for example, it was pretty obvious that there was no corruption there, I wouldn't decide it. I might make some disparaging remark. I wouldn't say on the record there is no evidence of corruption.
Okay. Now, in the 8 or 9 years you've been sitting as an arbitrator, how many times has corruption actually reared its ugly head in cases before you?
I should have done an analysis, shouldn't I? Quite a lot, actually. Not every time, but I've had quite a lot of forgery allegations of contracts being used. Yeah, so, I mean, not in every case.
No.
I should think in as much as 1/3 of cases, there's going to be some poisonous allegation of something.
Right.
Even in what you might call really blue chip cases.
Yeah.
I mean, they don't come across in gas pricing or electricity pricing cases on the whole. I've not had those, but I have had them in, serious energy disputes, seriously joint venture disputes.
Yeah.
Serious, yes.
Okay.
I have quite a lot, yeah.
And when you were sitting in the commercial court, did you have the same experience? 1 in 3.
I would have thought maybe it's just the sort of cases I attract or I'm given, people choose me as arbitrators because I can deal with fraud. Yes, I think it was about the same, actually.
Really? That's interesting.
I mean,
Okay. So you're the go-to for fraud. Okay, we've got that.
I don't want to, no, I mean, I'm obviously, well, no, I can't possibly advertise myself as such.
Well, it's interesting that there are so many around, which is rather a shame, isn't it? But there you are. Now, I wonder whether anyone else...
Can I just make a comment there?
Yes, of course. Yeah.
If I was asked the number of times the word egregious is used in memorials, that's used all the time. And actually, it doesn't mean fraud at all, but it's something nearly approaching fraud. So, I mean, the word egregious is thrown around a lot.
Yes.
When it shouldn't be, in my view.
It is. I wonder whether anyone in the audience has any questions.
This is like doing a Viva.
Anyone in the audience got a question on fraud in arbitration? No?
I'd be interested to know whether as counsel or arbitrators, you've come across this problem in an arbitration.
Yeah.
I mean, I'd
Okay.
be interested to have people's views
Yes.
as to whether they've had this thing. Do we raise it? Don't we raise it? Do we get the arbitrator to decide it? Yes.
Yes.
Not participating, and the loan agreement were in identical format and just didn't feel right. So I did some Googling around the names and found the names of the parties in a US federal court indictment where the assets of the loan proceeds had been frozen in a US court proceeding. And I came to the conclusion that these were fraudulent contracts, and they were using the arbitration as a way to legitimize to get these funds unfrozen.
Yeah.
And the question was, how do I deal with that? So I had to report it. So I basically gave the claimant, who was the only party representing itself, the opportunity to comment, and I laid it out bare and said, "This is what I found. Can you please, respond on these issues?" With being as neutral as I could, but presenting it. And in the end, they threatened to bring senior counsel advice, and nothing happened. And I terminated the arbitration on the basis there wasn't a valid dispute, and then couldn't get paid because I'd taken the view that the money sitting with the institution was potentially tainted. But that was quite and that was, how much do you as an arbitrator investigate when instinctively it feels wrong? But I could very easily have made an award. There's no respondents, not challenging. I had evidence that the loan had been made, and then that it was just a simple debt claim.
Yeah. That's really interesting. Actually, that's a good example of corrupt, the process being used as a corrupt means.
I mean, if you want my experience, I've only had one case that I can remember, and that was very recently, where corruption was placed before us fairly and squarely as a defense to a very substantial claim. And we did go through all the evidence on corruption, and we did make a decision that the contract was vitiated by corruption. But I can't remember any other case. I may have forgotten, but I can't remember any other case where corruption reared its ugly head in such a formal manner. I mean, what was going on behind the scenes in some of the cases, you just never know.
No.
But I can't think of anything where I was suspicious. I certainly have not raised it sua sponte, so I've never had a case where it was necessary to do so. At least so I thought. So we had different
That's interesting.
experiences.
But I mean, when I say fraud, I'm not just including corruption.
Yes, I understand.
I mean, my 30%, or is it 25%,
Yes.
would not be limited to corruption, would include
Yes.
other questions of illegality.
Yes, well, I'm talking about pure corruption.
Pure corruption, less,
Yes, much less.
much less.
Right. Very interesting. Anyone else with any questions? I can't
Mr.
see.
Gloster, we have a question online, so I can
Yes.
read out the question. The
Please
question,
do.
this question is from Chajuku. The question is, it appears that a tribunal faced with an allegation of fraud will have to deal one way or the other way with privity of contract and the vitiating effect of fraud. Should a judge or a tribunal not widely weight in favor of the vitiating effect of fraud rather than consider the lapse on the part of the party alleging fraud to abridge or completely prevent the occurrence of the fraud?
Could I have a look at it online?
Yeah, sure. It's a long question.
I'm not quite sure how privity of contract comes into this. But I get the point. Privity is like whether or not there is an agreement to agree or an actual agreement. Again, I think the answer to the question Chijoki, and thank you very much for your question, is that it all depends. If one could decide an issue or could decide the arbitration simply on whether or not somebody was a party to the contract, one might do so. It might not be necessary or indeed correct to consider the fraud allegation if indeed it was perfectly obvious that one side or another was not a party to the contract. So I don't think I agree with you. I go back to my slightly unsatisfactory previous answer that it depends on the circumstances of the case, the evidence of the allegation of fraud or corruption, and the relevance of it to the claim, which in a privity case, if the party is obviously not a party to the contract, it's obviously quite simple to decide that. Thank you very much.
I have one more question for you, Liz. Your title is Red Flags or White Flags. The question is, would you allow an expert to give evidence about what are red flags?
No, I wouldn't. That's a matter for me. I would obviously allow expert evidence where appropriate to identify what were particular money laundering or corruption regulations in a particular country, because it might be very relevant, for example, in the case of is this a commission, a legitimate commission, or is it a bribe, to have expert evidence from the particular state concerned as to whether this was a legitimate commission payment or a bribe. But whether or not this is a red flag or a white flag, should I be concerned about this matter, seems to me to be an issue absolutely for the tribunal.
Right. Thank you. Thank you very much. Well, I think I'm being kept from my bed and you're all being kept from a nice drink. So that's all from me. Thank you very much.
Well, thank you, Neil. I'm very sorry that you're not here in person, but I
Yeah.
quite understand why. And it's good to see you, even if across oceans.
Thank you for coming and for giving the lecture.
Thank you for inviting me.
Thank you, Mr. Neil Kaplan. And this is the end of our discussion session. There's a lot of challenging questions, and I would like to invite all our guests to give another round of applause to our honorable guests. And next, I would like to invite Ms. Helen Tan, the senior consultant of Herbert Smith Hughes, to deliver the closing remark.
Yeah, for delivering tonight's lecture, being the 29th Goff arbitration lecture. And also big thank you to Mr. Neil Kaplan for leading tonight's discussion, well tonight and also his early tomorrow. We have been focusing on fraud and corruption tonight, which are really life and global issues that we are facing today. And particularly, it is a real privilege for us to hear from you, Dame Elizabeth, as well as Neil, on these issues, because both of you have grappled with fraud and corruption, not just in your respective courtrooms as judges, but also more recently now as arbitrators. And this year, we have heard a lot of discussions or questions on threat to international arbitration, whether international arbitration is still the better, faster, cheaper, reliable, private method of resolving international commercial disputes. And with the case that Dame Elizabeth has just, explained to us in detail, the Nigeria and PNID case, added to those challenges of, whether arbitration is getting more expensive, it's more time consuming, it's getting less affordable, or sometimes even a gamemanship, is the question of whether fraud and corruption in arbitration is being dealt with, and whether the arbitral tribunal can have the power, the mandate, and the courage and the toolkits to call it out and address it. And so in this regard, your experience on what an arbitrator can practically do and should not fear from doing when faced with fraud or corruption in arbitration proceedings is invaluable. And here I would also like to answer one of your questions, Dame Elizabeth, because you asked whether we have any experience coming across a fraud or corruption situation. I would say that I had a very limited experience. When I was a trainee many, many years ago, a very short-lived case. I called it the 不好说 case. 不好说 means in Chinese, difficult to explain, or I can't really say. So this was a case that we handled for like a couple of days or a few weeks, and then we got sacked. We were representing the respondent. Interestingly, it was a case where the respondent was sued by the claimant, which is an individual, in relation to a huge sum of consultancy fee in relation to a project in Nigeria. So when we were meeting with our client, we asked our client, the respondent, the engineers and the bosses, like what did this claimant provide to you? What was the claimant's role? And to every question, the answer is 不好说,不好说. And then at that time, my boss keep asking me, what is 不好说? So I need to explain to my boss, 不好说 means difficult to explain. So, for all the questions, so what was the role of this consultant? Did he really help you to win this project? Is there a direct, causation between this consultant's work and the winning of the project in Nigeria? The client just said 不好说, and then within days, the client sacked us because they want to settle with the claimant. And we think our suspicion was that, the whole 不好说 thing was because it was not really consultancy. It was really to help the claimant help the respondent to either bribe or use connection to win the project in Nigeria. But I would think that if I had the opportunity to, come across with that client again, I would want to encourage him, and I hope I will be able to say that if this goes to arbitration, like you don't need to settle, we will have arbitrators who have the courage, have the power to look into the things that are 不好说, and then, to find out what really happened. Just like in court, in arbitration, there should not be things that are 不好说, and then as a result, you would need to, deal with it in the other way or settle it reluctantly. So this is part of my very limited experience of dealing with a corruption case. Finally, before I wrapped up, I would also like to extend our heartfelt thanks to City University School of Law and the HKIC for organizing tonight's event. The Goff Arbitration Lecture, which, as Professor Ling Feng has mentioned, has its history dated back to the 1990s and have now really become a time-honored tradition that all of us look forward to every year. So it is our great pleasure, Herbert Smith Freehills, to be the sponsor of this event, and we all look forward to seeing you again next year. Thank you.
Thank you, Helen, for this wonderful closing remark. Next, I would like to invite Ms. Joanne Lau, the Secretary General of HKIAC, to deliver the final closing remark.
Thank you, everyone, for joining today's Goff lecture, the 29th Goff Arbitration Lecture. It is a great privilege for HKIAC to serve as a venue sponsor for this year's lecture. Our sincere thanks to the City University of Hong Kong, not only for their sponsorship of the event, but also for their dedicated role in organizing the Goff lecture year after year. We also extend our deep appreciation to Herbert Smith Freehills for their generous sponsorship and support for the event. And of course, many thanks to Dame Elizabeth for delivering such an inspiring and insightful lectures. I think today we explored a lot of tension in arbitration for arbitrators to think about. Do they only have a contractual mandate? How does that contrast with public officers? Should they adjudicate based on party submissions and evidence, or when should they intervene a bit further and to find the truth and to raise questions on their own initiative? So lots of food for thought. I think as an institution, it also provides a lot of questions for us to think about as well. Even though we're administering arbitrations, we tend to take a light touch approach. But when should we be careful in preventing things like sham arbitration, fraudulent arbitration, things which could undermine the integrity of proceedings and create risks for how parties view arbitration, into whether they see arbitration as a legitimate dispute resolution process. So I think all those are really insightful insights for us to think about. Many thanks to Neil, of course, for leading the discussion. I thought it was particularly fascinating that we saw so many exam questions, but Dame Elizabeth was up for the challenge. And so thank you very much for sharing such frank and clear views. I thought it was, yeah, a wonderful, wonderful discussion. And of course, thank you to everyone who is present here. It's late in the evening, but I think your attention and participation illustrates how vibrant the arbitration community here is. And it makes it extra special for HKIAC to continue to support the Goff lecture. And before I finish, I also want to mention that this year is a very special year for HKIAC as we are celebrating our 40th anniversary. Our Hong Kong Arbitration Week, our flagship week, is set for 19th to 24th October this year. 19th of October is a Sunday, so we'll start our celebrations on a Sunday this year, so mark your diaries. So we warmly invite you all to attend, and for those who are overseas, please come to Hong Kong then. And not only is the Hong Kong HKIAC anniversary a special year, next year is also going to be very special because I mentioned at the start, it's the 29th Goff lecture this year. So next year is the 30th anniversary of the Goff arbitration lecture. So we hope to welcome many of you back for next year's Goff lecture. Thank you, everyone, and thank you again to Dame Elizabeth.